I would now like to turn it over to our host for today, Jonathan Louis from RealManage. Jonathan, please take it away. I'm going to shut up and hide myself.
Thank you so much, Jeff. I'd like to be working from your office space. Hi, everyone. My name is Jonathan Louis. I'm the president of business development for RealManage nationwide. We are the third largest management company in the country, and we're in 19 states. And we have, in Florida, we have about 1,000+ communities. I've been in the business of operations of 4 and 5 diamond resorts and condominiums for a little over 40 years. And I do have all the required designations, including the LSM and the PCAM. RealManage specializes in condominiums, homeowner associations throughout nationally, as I mentioned. And right now, I'd like to turn it over to Lisa Magill. Lisa is a board certified specialist in condominium and homeowner plan developments, one of very few in the country. And she's also an attorney with Kaye Bender Rembaum. Lisa?
Well, thank you, Jonathan, and thank everybody for being here today. Really happy that you have decided to serve as a leader on your board of directors or as a volunteer in any other capacity. And for you CAMs out there, some of the information presented today may be a little bit rudimentary, but we hope we go through some of the real life situations that you have to encounter on a daily basis. So I'm going to start right away. And we'll begin. So this is the DBPR board certification for condo and HOA directors. And as Jeff mentioned earlier, it is absolutely required for condo and HOA directors that are new or that have had any gap in service. Now, I can tell you, if you only had a 2-hour gap in service, I find it highly unlikely that you'd be penalized in any way. But again, for that purpose, I do wish to thank you for, again, attending and joining us with your questions and expertise to the extent necessary. So my name is Lisa Magill. I'll have my information, contact information, well, here and also later in the presentation. And of course, both RealManage, Jonathan Louis, information will be provided to you after the event is over. You'll receive an email with that information again. So we join you. Why are we here? We're here because directors may submit a proof of an educational course attendance in lieu of signing a certification form. Written certification is valid as long as you serve on the board without interruption. And if you're an association that must have a website, meaning any association with over 150 units or more, any condo association in Florida with over 150 units, then this certification must be posted on the association website. So make sure that you get that information to the board and have the board make sure that that is posted so that you're in full compliance. Now, this said, bills filed in the 22 legislative session would have required both of these requirements, but that did not happen. So in the 22 regular session, there was no legislation passed that impacted condo and HOA owners in the state of Florida, but there was a special session, and we will talk about some of the laws associated with the special session. So what are we going to talk about today? We're going to talk about a bunch of things. The division requires us to review 5 out of 7 topics that that they feel is necessary for you to adequately serve in a leadership position for your community. Well, I'm first going to go over some board member basics. That's the corporate governance. That's the statutes that control community association operations, and your fiduciary duties. Now, obviously, fiduciary duties are a primary importance to community association operations and really establish your standards for your service. So you want to be very cognizant of what you need to do in order to adhere to your fiduciary obligations. What statutes and codes are we going to be talking about today, or what are you governed by? I also wanted to mention that Jonathan will participate because with respect to on the ground operations, in connection with his experience, because I do find that these presentations are far more beneficial if there is some real life experience entered into the discussion. So statute and codes governing associations. For condominium associations, you're governed by Chapter 718 of the Florida statutes, Rule 61B of the Florida Administrative Code, both chapters 21 and 22. For homeowners associations, hopefully you know that you're governed by Chapter 720 and the chapters 80 and 81 of the Florida Administrative Code. But I talk about these two items in a vacuum, the Florida statute chapter and a portion of the administrative code. You're governed by a whole host of other laws and codes that you should have some ancillary familiarity with. I mean, obviously you're governed by building codes. You're responsible for the administration and management of a facility. That facility needs to be in compliance with code, and the work that you perform needs to be in compliance with those codes. And that could be the Florida building code, that could be local building codes, and other types of ordinances that impact your improvement, repair, and operation of the property. You're governed by federal laws like the fair housing and discrimination laws. That's something that I know many of you confront, and I know Jonathan confronts on a very frequent basis. You're governed by other federal laws like laws pertaining to the installation of satellite dishes and the like. So just because I list these two items in a vacuum, please be aware that there are other issues of which the association bears responsibility. But here's the overall encompassing issue that I'd like to get to you today, and that's the fiduciary duty responsibilities of members of the board of administration of a condominium or a homeowners association. First thing I'd like to say is you should not be worried about personal liability. And there's been a lot of talk about directors being liable for this, directors being liable for that. So long as you comply with the standards outlined in the Florida statutes, and this happens to be in the not-for-profit Florida statutes, then you should not suffer any personal liability because the association is required to indemnify you. And that indemnification applies regardless of whether you have the directors and officers insurance, which of course you should have, so hopefully you do, and or whether there's actual coverage for the particular claim. So the standards as listed in the statute is you have to discharge your duties in good faith, with the care of an ordinarily prudent person, and in the best interest of the corporation. So you are going to be exposed to personal liability for criminal acts, recklessness, your bad faith or willful and wanton disregard for the lives and safety of others, and items that where you usurp the corporate opportunities or take actions for your own benefit as opposed to in derogation of the benefit of the community association. And there's plenty of cases out there that have ruled and had the opportunity to rule on this issue. Most of the cases, I'm glad to report, do find that the directors are entitled to indemnification, regardless, as I said, of the D&O coverage. But there are cases that have found directors personally liable. In one case of which I'm familiar, the directors, the owner of a recreation facility, there was a rec lease for a recreation facility attached to the association, and the association fell behind in their rec lease payments, and the rec lease owner was prepared to take action, legal action against the association and the individual unit owners, but also offered the association the opportunity to buy the rec facility to forestall any future rent payment obligations. Well, the association, it's unclear to me whether the board of directors actually even notified the members of this opportunity, but the decision was made that it was really not feasible for the association to buy the property. Unbeknownst to everyone else, two of the directors on the side went around, cut a deal, bought the association property, and then started charging the rent, including escalating the rent against the individual, against the association and its members. They were found to have acted in their own best interests rather than the best interests of the corporation and held personally liable in those circumstances. So there are cases where personal liability is a possibility. Obviously, if there's defalcation, theft, or fraud, there's always going to be opportunities for personal liability. What I want you to understand from today's presentation is, listen, you can do your job. You do the job as best as you can. You make decisions based upon information that you've gleaned through this process, and you will not be held liable for it. So you're not expected to be accountants. You're not expected to be architects or engineers. You're not expected to be attorneys. You're not expected to be PCAMs, professional, those that have received the highest designation for community association managers. You are expected to have an interest in what's going on, and to read and be aware of corporate operations, and understand what you're voting upon, participate in the vote, and make those decisions as best as you feel that you can.
That being said, if we can go back to that slide for a second, that being said, it's important to realize that the board of directors is in fact the manager of the association, and you can assign job duties and responsibilities. With a management company, it would be via a management contract, but you can never assign responsibility to the management company. That lies solely and totally on the board of directors.
Well, and I hear that often. Hey, that's the manager's job. Oh, the manager's supposed to take care of that. No, you're ultimately, the buck actually stops with you. You're considered the owners or the operators of this corporation, and you're hiring managing agents, you're hiring attorneys, you're hiring accountants to perform services for you, but you're the one that, you are actually driving this bus. It's your corporation that you're running. So the specific language in 718, that's the Condo Act on the fiduciary relationship, is found in 718.111. It says that you have the fiduciary relationship. It also prohibits any solicitations or offers to accept or accepting any service or value for which consideration has not been provided. What is this? This is the anti-kickback provision. And kickbacks are more difficult to ferret out than maybe some other actions on the part of directors that would be in derogation of their fiduciary obligations. But there have been cases here in Florida, and particularly South Florida, where the investigators, the law enforcement, has become aware of certain types of scheme, and people have been actually arrested and convicted for taking kickbacks or even providing those kickbacks. Let's talk about the hierarchy of the governing documents. This is your lifeblood. I mean, everything kind of flows, other than your statutory powers and obligations, everything flows from your governing documents. So in a condominium, the document of highest priority is the declaration of condominium. In a homeowners association, it's typically called the Declaration of Covenants and Restrictions. It could be called use restrictions. It could be some other name, some other type of name to the actual document, but they both serve the same function. In a declaration of condominium, that's the document that's filed with the division. It actually creates the condominium. So that's the document that actually delineates which portions of the property are going to be considered units, what portions of the property are going to be considered common elements. It outlines all of the responsibilities for maintenance and repair, outlines responsibilities for insurance, contains all the statutorily required provisions. And a declaration of covenants is somewhat similar, but also different at the same time. Both are recorded against the property. Both are land use covenants. So they are contracts for which all owners are obligated, but they're also covenants that run with the land. They're more of a property right. In the HOA scenario, the declaration will likewise allocate responsibilities for maintenance and repair, allocate responsibilities for insurance, and otherwise discuss the powers and duties of the board of directors. The document that creates the actual corporation, so I get this a lot, even with staff members. There's a distinction between the association and the community. So if you live in Happy Land condominium, you're living in Happy Land condominium. But the corporation running Happy Land Condominium or operating and managing could be called Happy Land Condominium Association. So there's a distinction between the actual community and the association that operates the community. And they don't always have to have the exact same names, like Happy Land Condominium, Happy Land Condominium Association. You could be in Happy Condo of the Palm Beaches, and the name of the association is Happy Land Condominium Association. That's something to pay attention to. But the corporation that is for which you serve as a member of the board of directors is created by filing the articles of incorporation with the Division of Corporation Secretary of State. The articles of incorporation are typically pretty basic documents and just set out the requirements of the corporate statutes, talk about the what is a board, what is the the corporation's purposes and powers, membership, voting rights. The bylaws will contain a lot of the do's and don'ts, or the actual operational procedure. So the bylaws are going to have a lot more meat than the articles of incorporation when it comes to, what your meeting procedures, how you call meetings, how you adopt your budget, what should be included in your budget, what kind of notice do you require for meetings, what kind of enforcement powers do you have for remedying violations. And all the way down at the bottom of the list are the rules and regulations. And these are typically adopted by the board of directors, and that concerns use of the property for the most part, or could also concern corporate operations. So use of the property, what the hours of operation of the pool, when you can use the laundry facilities, parking, some of the issues that affect you on a day-to-day basis. For operational procedures, your rules could contain procedures for inspection of the official documents. They can contain procedures for or governance of how you participate, or the manner of participation at meetings and the like. So your rules and regulations do fall to the bottom of the hierarchy, but they are very important because your rules and regulations are not necessarily recorded and are mostly, for the most part, adopted by the board. So you have a lot more flexibility with changing certain things, changing the hours of operation of the pool. Or when we had the whole COVID debacle, it gave the board of directors, for which boards had rulemaking authority, the power to restrict certain activities, restrict access to certain amenities, change procedures on access or ingress and egress through the property. Those rules are important and they do have a role, but there is a test for evaluating the enforceability, and we're going to talk about that a little bit later. So elections, I don't typically spend a whole lot of time talking about elections when I do these board certification classes. Why? Well, most of you have already been elected, and that's why you're taking your board certification class. But there are certain things that you want to talk about when it comes to elections. On the condo world, there's a very specific procedure where you have a 60-day notice and a second notice that's only 14 days in advance. There's an advance candidate eligibility requirement. There are requirements when it comes to the actual casting of the votes, but there is now electronic voting, and hopefully we'll talk about that a little bit. What I do want you to realize in elections for condos, the eligibility criteria is determined by statute. So membership is not necessarily an eligibility criteria for serving on your board. This is true in both HOAs and condos. The eligibility to serve on a board of directors for a not-for-profit corporation is that you're over the age of 18. If you want to limit board service to members, meaning owners, or some other incantation of category of persons, whether it's owners and spouses, or residents, or owners and immediate family members, that's something that you need to take a look at to see if your documents already regulate it, and if they don't, make provisions for such regulation. Jonathan, do you see a lot of communities where non-members are serving on the board? I think I only have 2 or 3.
Yeah, we only have a few. It's rather unusual. Usually it's the owners are the ones that can be directors, but anyone can be an officer. So there are boards where you have maybe a president or a treasurer because of their particular qualification, but they're not listed as an owner, but they have that qualification to serve as an officer.
Right, and your officers don't necessarily have to be, all of
Right.
your officers don't have to be members of the board, but if that's the case, then they're non-voting. They don't
Right.
have the right to vote in board decisions.
Exactly.
Or the term limits. Term limits came into effect in what, 2000? Tell me what year it was now that I don't remember, but there was an 8-year limitation on service on the board of directors, and the law, oh, it says right on my right on my slide, confirms that the term limits for 8 years for condos is calculated from the effective date of that statute, which was 7/1/2018. So you still have a few more years to serve if you've been in continuous in service for that entire time. Now, of course, the term limit is not going to apply if you don't have anyone else that's willing to serve on your board of directors. You're the only candidate that's available, or if you receive a certain amount, percentage of the vote that's over that limit. Typically, we really don't see that, and obviously, we haven't even come to that point yet. For HOAs, very, very different procedure. It's largely determined by the governing document. So in condos, while there's a statutory procedure that basically tells you what you have to write, what kind of ballot you have to use, what kind of envelope you have to use for the ballot, in HOAs, it all depends on the governing documents. Most of HOAs do allow proxy voting. Many of them allow general proxy voting, not even limited proxy voting. So that's something that if you are having issues with board members remaining in service for an extended period of time, maybe it's time to take a look at how you conduct the vote and what levels of approval are necessary, and what quorum requirements will be necessary for that vote to actually take place. I often see HOAs using the same process as condos use because they feel it's a good process, people understand it, they know it, but really they're only entitled to undertake the absentee balloting process if their governing documents authorize absentee balloting. Many do, some do not. So that's something to take a look at. For recall, which is removal of the member of the board of directors, both statutes require a majority of the membership to recall either a member or members of the board of directors. So once you're on the board, you remain on the board until, of course, your term ends or you resign or otherwise fail to serve. But the membership has the ability to say, okay, this person is not working out. We want to get rid of her, him, or all of them. And doing so through either a vote by, at a meeting via proxy or in person, typically via a written consent form. The division publishes the whole procedures for recall with a sample written consent form. So if you're one of those in the audience that are not happy with your selected board of directors, and you believe that the majority of the other owners feel the same way, you do have the ability to remove them mid-term by following this recall procedure. Both recall procedures require the board within 5 days of receipt of the votes or the written consents to recall to meet. But there's a very big distinction between the HOA side or the condo side. On the condo side, the board has to, or the board really doesn't have to do anything unless the recall petitions are facially invalid, meaning there's something has to be drastically wrong for the board to be able to say, hey, this is no good, we're not going to accept it. Joe Schmo is going to remain on the board of directors. And if that happens, it's up to the unit owner representative to file a challenge. They can file the challenge in court or through the arbitration process now. So the distinction on the HOA side, and this is the way it used to be in condos, is that on an HOA side, when the board meets 5 days within receipt of the recall ballots or the vote, the board has to decide whether they're going to accept or reject the recall effort. And technically, of course, the board can only reject the recall effort if there are deficiencies or defects in the procedures utilized by the recalling unit owners. But the distinction here is that the board then, if it wants to reject the recall, then has to move forward with challenging the recall effort. So on the condo side, if the board does nothing, or it says the recall, the recall's invalid, we're not removing this person from the board of director, it's the unit owner that has to take it to the next step. On the HOA side, it's the HOA that has to move to a tribunal, whether it's the court or the arbitration program, to say, hey, we think that this recall was no good, did not comply in one way or another, and we feel that the division or the court should uphold our decision to reject the recall effort. In an HOA or either process, there's a challenge. The removed board member who feels that they were wrongfully removed and the board, was in cahoots or something with the recall effort, has the ability to challenge the recall itself. So eligibility, we talked about this a little bit. This is the statutory requirements. If you're not eligible for board service, if you have been convicted of a felony and you have not had your civil rights restored for 5 years, you're not eligible in the condo side if you have been suspended or removed by the division. Another big distinction that resulted from the 2021 changes to the law in a condo, if you're delinquent in the payment of an assessment on the date of the candidate eligibility, the last day to submit your notice of intent, then you're not eligible to be a candidate. You won't be listed on the ballot. On an HOA side, it's if you're delinquent in the payment of any monetary obligation. So the statute before that, both were declared the candidate ineligible if they owed any money to the association for any reason. In the condo side now, it's only if you're delinquent in the payment of an assessment. And what does delinquent in payment of assessment means? That means that it's not paid on the date due. Now, the date due is typically the first of the month. Yes, we all have grace periods and late fees are not imposed for a specific period of time, but that doesn't mean that the assessment is not late. So if you're someone or your residents are typically on an automatic pay program and the payment isn't drawn until the second or the third, or the first of the month occurs on a Saturday or Sunday and the payment's not going to be drawn until the Monday, you need to be cognizant that payment needs to be in the association's coffers on the date of eligibility in order for you to be eligible. I know it sounds a little bit unfair because particularly if you're on automatic payment and you've been a faithful payer over years and years. But again, this is the requirement. In a residential condo of more than 10 units, co-owners can't serve at the same time if they only own the same unit. So if I own one unit, my husband owns another unit, then, then we're both eligible to serve because we both have ownership interests that are separate from each other. And here's where I talk about that happened in 2021. So a person is delinquent if their payment is not made by the due date of the assessment. Okay, important consideration. Had a lot of calls about that before 2021, where we did not have direction from the state, but the division always took the position that if payment's not in by the first, then the person is not eligible. Meetings. How do you call your meetings? Well, that's largely controlled by statute, but also by the bylaws, like I discussed earlier. So particular issues to address for today, because I'm not going to go through the actual, 14 days or 10 days or 2 days, but for the annual meeting, for HOA, well, condominium associations, the annual meeting must be held within 45 miles of the condominium property or the location provided in the bylaws. The annual meeting for an HOA, if you have someone who is disabled or has some kind of mobility impairment, the annual meeting must be held in a place that is accessible. The method of calling the meeting will not apply to annual meetings, or but typically your bylaws will say whether the meeting notice for other than annual meetings is 10 days, 14 days, or something like that. And elections occur in conjunction with the annual meeting. Go ahead, Jonathan.
Lisa, I want to mention that one of the things I've found to be really important over the years is that when we take over the management of an association, one of the first things we want to make sure it goes right is the annual meeting. So usually what we do is we rely on legal counsel putting the package together, because there are so many different areas that one has to look at. And I can't tell you how many times we've found situations where the annual meetings were not being conducted the way the documents required them to be conducted. That's why you have legal counsel. So legal counsel puts the initial package together, and then you know that you have a template that's going to work, and you could perhaps use that template going forward. And once in a while, because of how legislation changes, have your legal counsel review it. But that first package going out to the members of the association really needs to be flawless. And when you're relying on a professional that you're paying, like legal counsel or a management company, you are entitled to listen to their advice, because you're paying them for that advice, and you can't be held liable for that. But it's important that you have legal counsel do that initial package, and at least make sure you have a template that was done by an attorney representing your association to begin with.
Yeah, I can tell you this is especially true on the HOA side, because every HOA is different. So, and I think it's unfair. Personally, I think it's a little bit unfair for the association to require the manager to actually create that initial template, because again, some interpretation needs to be made of the governing documents and how they are affected by the statutes when creating that initial template. I can tell you from attorneys, it's very, very nominal cost for the attorney to prepare your, I was just doing this morning. Variances can include whether or not voting certificates are required, and if voting certificates are required, when are they required? Are they required for the married spouses? Are they required for LLCs? I mean, most of these kind of documents or HOA documents don't even mention limited liability companies. They talk about corporate ownership. We can talk about whether or not what the quorum requirement is for the particular property. Now, in a homeowners association, the quorum is 30% unless the bylaws provide otherwise provide a lower number in the bylaws. In the condominium association, it's a majority unless the bylaws provide otherwise. But that's something to take a look at, because sometimes it's 50%, sometimes it's 50% plus one. I mean, that it doesn't seem like it's a difference, but it is a difference. And of course, the business to be conducted at the annual meeting may vary from property to property. So those are all little things for you to take a look at. Special meetings of the membership must be called by the board or upon written request of at least 10% of the owners, unless there is another meeting method contained in your governing documents. Election challenges are not as frequent in the condo arena as they are in the HOA arena, and that is due to the specified procedures in the Condo Act and the Florida Administrative Code. Those procedures came into, well, at least the statutory procedures came into place, I believe, in 1992. So people are very, very familiar with that process. But at all meetings, members have the right to participate, the right to attend, and the right to participate. So this is one of the areas of rulemaking that is permitted by the statute, where the association can determine or create guidelines for member participations. So on the right to speak in the condo, members can speak on all agenda items. On the HOA, since the agenda requirement is not as specific, when you post a notice of a meeting for a board meeting, you don't necessarily post notice of the agenda. In a condo, when you post notice of the meeting, board meeting, typically 48 hours in advance, then you would also include the agenda. So on a condo, the issues discussed at the meeting are limited to agenda items, and owners are limited likewise to those agenda items, unless of course the board opens it up for general discussion. In an HOA, all items open for discussion are subject to fodder by the individual unit owners. So if that's the case, if anybody opens something up, then that discussion can take place. Members have the right to record, video record, or audio record meetings. It's subject to reasonable rules. In the condo, there are specific rules regarding, regarding advance notice and placement of the cameras so that it doesn't interfere with the conduct of the meeting. Again, I always recommend that the association adopts reasonable rules governing the frequency, duration, and manner of member participation. I mentioned this earlier. In an HOA, the meetings have to be held in an accessible location. If you have someone who is disabled and has mobility impairments. And for voting, HOA very, very frequently will allow general voting by general proxy, meaning that the proxy will just say, I appoint X to vote in my place, and X, whoever the designee is, has the right to vote however they see fit. More and more now we're seeing that HOAs develop and adopt a limited proxy requirement so that the people that are actually voting have a say in what is taking place. On the condo side, limited proxies are required for most items, and proxy voting is prohibited in the election of directors. General proxies are relegated to ministerial issues like let's motion to adjourn, or motion to go into recess, or things that are really non-substantive in nature. Okay, electronic notices. Now, electronic notice is different than electronic voting. So use of electronic notice, I think, is a no-brainer. In fact, I'm a very big advocate of electronic voting as well. But electronic notices, you only can use like email to send your official notices if you have consent in writing on file. So if you don't have something in your files that say from that owner, hey, I want you to send me notice electronically, and here's the email address, or fax, nobody uses fax machines anymore, but here's where I want my notices to be sent. If you don't have that information on file and you send an email notice because it's so much easier and it's so much faster and it's so much less expensive, well, then you can have all kinds of challenges to any of the actions taken at any of those meetings, including the annual meeting and including the agenda, the election of directors. So, I don't know where they said the association was required to obtain facsimile numbers. I apologize for that, but yes.
I think it's just to ask for facsimile numbers as opposed to insist on it if they have it. So there's an option.
You do insist that they provide you a fax number, because I don't even know if I have.
No, I'm just saying that I think it's written there because you ask for both in case some person prefers a fax instead of email. There's some folks that still actually use a fax machine.
Okay, well, I haven't used a fax in a really long time. I remember when I first started practicing, this is an aside, we had the fax with the paper, the liquid paper. And it would always get jammed up, and we'd always receive a fax for a hearing, a notice of a hearing, like the day before the hearing was to take place. So at 4 o'clock, we're trying to scramble around our entire office, figuring out who is able to attend a hearing the next morning. Email has just made things so much easier. Now, you can't use electronic notice for recalls or for retrofitting of the condominium with fire sprinkler systems. There are people that say that you can't use email or electronic notice for other purposes. And so before you decide to solely go with electronic notice for some type of meeting, for some type of announcement or statutory requirement, including sending out the year-end financial report, just please check with your attorney to see if that's problematic in any way.
Do you think we could perhaps, there's a couple of questions here that that we could possibly, there's one particular, I think, that covers some of the material that we just did. The board director does not achieve certification within 90 days of being elected. Are they suspended until such certification is obtained? Are they identified as a board member even though they did not obtain appropriate certification?
Wow, so you are correct. The person that raised this question is correct about the first items, that they are suspended until they become certified. But are they identified as a board member? I would say yes, because even though they did not perform the ministerial function for solidifying their board service, they were still elected to the board. They're still a volunteer, and the whole point of having this indemnification is so that you will have volunteers that will be willing to devote their time and effort to association functions. Now it says, can a newly elected board member self-certify by sending the document saying he or she has met all requirements? And yes, that is available under the statutes as they currently are written. So attendance for a class or a self-certification form. The self-certification form basically just attests to the corporate entity that I've read all the governing documents. I'm familiar with the statutes and the governance of community associations, and I promise to uphold these to the best of my ability. And there was also a question, is the certification only required for buildings with more than 150 units? No, that's not correct. I mentioned the website is for associations is required for associations that condo associations that have 150 units or more, or where the condo has 150 units or more. Having a website is, of course, is a very, very beneficial tool. It's useful for a lot of reasons. So I always recommend it, particularly when it comes to access to records that we'll talk about in a little bit. One more question that I want to talk about before we move on. Actually, there's a few here, but what about if the president does not follow the governing documents, makes decisions without board approval, basically just goes rogue? What happens under those circumstances? Excuse me 1 second. Okay. What happens with this? Well, you need to internally control that. So if you have 5 members on the board, if you have 3 members on the board, and one person, whether it's the president, whether it's some other officer, whether it's a member of the board, another member of the board of directors without an officer position, you need to rein that in, because just because a president goes ahead and signs a contract without approval of the board does not mean that the association can avoid all responsibilities under that contract. When you're a president of a corporation, you have what's called apparent authority. So if I'm president of my association and I'm working with a vendor or service provider, and I say, oh, we really want to hire you, you're fantastic, I'm going to sign this contract, we're going to pay you X. That provider does whatever work is necessary to start providing the services, and then lo and behold, the other board members come out of the woodwork and say, who are you? We don't want you here, and we're not paying you. That doesn't work. So how do you do that? Officers can be removed at any time by the other members of the board of directors. That only requires a board meeting. A board meeting only requires 48 hours notice. All you have to do is put on the agenda reconsideration of officer positions or reorganization or however you want to list it. And at that meeting, one of the other members will say, I move to remove Joe as president and appoint Sally as president in his stead. And you have a vote on that, the majority vote wins, then you have somebody else in that president position.
Another way to mitigate that, Lisa, perhaps would be to have the board make a motion as to what the thresholds are for approval by the board president. So if it goes over a certain amount, it requires a board vote, so on and so forth.
Say that again, right? Well, again, though, if you have a limitation in your, whether it's your open documents or whether it's in your management contract or whether it's through a written resolution, limitations on powers and authorities, we see this a lot of times, that the president is only allowed to spend up to $500 without board approval. Well, that doesn't necessarily stop the president from spending more than $500
Right,
without
which
board
obligates,
approval.
yeah, right, which
Yeah.
obligates the association.
Okay, and there's a good question here. Fiduciary duty, ordinarily prudent person, is the standard higher if the board member is an attorney, an accountant, as is sometimes the case in other states? Well, I can't answer for other states, but I have heard that argued. I'm not aware of any law that has declared the fiduciary duty to have levels based upon the characteristics of the actual director. Now, again, that's an arguable point. You get into court and you want to argue that so-and-so violated their fiduciary duties because they should have known better. Well, that is something that the court will take into consideration. And there's some factual issues to be decided there as to whether that person was really operating in the best interest of the association. If you're not a board member and you're considering becoming a board member, is there a time limit for certification? You could take the certification class up to a year prior to your board service or up to 90 days after you are actually elected. And if a recall of an officer of an HOA board has been requested with 10% of the membership, can a limited or general proxy be allowed? There are no
That's one of the areas where you mentioned earlier that a proxy would not be allowed, I think.
in an
In a recall.
HOA, right, you have to have the actual vote of the owner to recall the director. So let's move on a little bit, because we have a lot of questions about that certification, which is unusual. I don't really get a lot of questions about certification. Although this one's funny. If a board member submits the certification saying that she or he met all the requirements for the HOA, when the member is actually part of a COA, which is a condo association, is the certification valid and what are the possible consequences? I think that's just an honest mistake. I would ask that person to re-sign a new certification, self-certification form. Okay, so.
Shall we go ahead with the board member obligations?
How come my document won't? Okay, electronic voting. I think electronic voting is great. Jonathan, have a lot of your communities adopted electronic voting?
Yes, what we do is there's a couple of companies out there that do a really good job of it. And we just turn it over to them and they handle everything from soup to nuts. And it makes it so much simpler for the association and it's a nominal fee.
I think it could be less expensive, particularly in large communities. I think it could be far less expensive when you have owners that live in other countries. You have those mailing costs, and in those large communities, your duplication costs can be enormous. So I think it's something that it's definitely very, very easy to use. If you convert or elect to utilize electronic voting, that doesn't apply to every single owner. So owners still opt in or opt out. If they don't have computers or they're not computer savvy or they don't feel comfortable, voting electronically, they still have the ability to vote by paper and written ballot. And it's so easy to do. Basically, you just have to have the board members adopt a resolution that describes how the program is going to be implemented. And of course, the board member resolution is adopted at a meeting that's noticed 14 days in advance, as opposed to 24 hours of demands. And it talks about the procedures and the deadlines for owners to either provide their written consent or how they opt in, how they opt out, how they get their passwords or their user IDs and the like. But I agree with you. There are some companies out there. There are many companies that provide the service that are compliant with the Florida requirements, and they just make it so much easier for you to move forward. Board member obligations. So this is fiduciary duty. Right back to fiduciary duty. Prepare for and vote at meetings. I just received a question the other day. Well, so-and-so doesn't want to vote. Are they allowed to do that? Well, you can't hold somebody hostage or by the neck and say you must vote on this motion, but that's your job. Your job as a board member is to make those important decisions. So whether it's something between choosing one vendor or another vendor, or whether it's imposing a special assessment for a project that's necessary, even if that's not a popular decision. I even had a situation recently where the director did not want to vote in favor of the new insurance policies because the premium went up by 200% or 150%. So they was like, no, I can't vote in favor of this insurance policy or this insurance coverage if we're going to have to pay that much money. And you know what? You're statutorily obligated to provide for our insurance. So you're statutorily obligated to meet your requirements. And in my opinion, the option to say, oh, I'm not voting or I'm opting out or, I'm bagging out of this one is really not a good one. You can't force someone to do it. But again, in my opinion, your fiduciary duty requires you, if you're going to be at a board meeting, to vote on that board meeting, vote on that issue, unless of course there's a conflict of interest. You must disclose all potential conflicts. As a board member, one of your primary responsibilities is maintenance of the physical property and improvements. So you are not, as I said, not expected to be attorneys and accountants. You're not expected to be facilities managers. You are expected to work with people that can provide you the advice and counsel that you need to ensure that your buildings are being maintained properly, appropriately, and in a safe manner. Aware of financial operations. It hasn't been as prevalent in the last few years, but I remember a period of time where it seemed like every other week there was somebody being accused or found to be guilty of defalcation, stealing association funds. In fact, there was a huge case from a management company in Southwest Florida not too long ago where an enormous amount of money was embezzled from community associations, and it really left them in dire constraints. So just because you have a treasurer and the treasurer has been there for 15 years and you have a management company and otherwise you feel very, very comfortable, you're a board member. You need to have some cognizance of what's going on with the finances of the association and have some check and balance in order to ensure that the finances are being handled appropriately.
Yeah. Lisa, there's something that comes up fairly often is that sometimes certain board members are a little bit confused between not-for-profit and for-profit. So they treat the association budget and the finances as if it was a for-profit corporation and don't spend in associations, the money that you collect is a direct relation to the expenses that are anticipated to be spent to maintain that facility. So
Right.
It's not a situation where you can not spend the money and save the money because someday you're going to need it. You need to maintain the physical property. So there's many times we've come into a situation where the certain board members did not fully understand the financial situation of the community.
Mhm.
And they were just saving money and not spending it when they had it available to them. And it ended up costing more in the long run to fix things up. So with associations, your total expenses is what you collect from the residents. And that money, for the most part, needs to be spent to address those expenses.
Right, and that doesn't preclude having an overage at the end of the year. Remember, you're budgeting for your anticipated expenditures.
Right.
You're not going to be 100% on the dollar. In fact,
Exactly.
if you speak to accountants, they would like you to have a little bit of flexibility or wiggle room just in case there are unexpected expenditures that do come up, or in the event that you have some delinquencies out there. But that's the whole purposes of budgeting. And when I say budgeting, that's for not only your short term, your yearly budget, but that's also for your long-term needs.
And for those board members that need the help, don't hesitate to call your management company. Say, I'd like you to come in and explain this financial statement.
Oh, yes.
You've got to feel comfortable asking them, how do we do this? Do we have enough cash reserves? Can you show us what does this balance sheet actually mean? And these are things that are critical to running an association and part of the fiduciary responsibility of the boards.
Right. You're 100% right. Plus the distinction between the cash and accrual accounting can be, somewhat confusing because you're looking at figures and then you're looking at the bank statements and they don't seem to mesh for some reason. So yes, please talk to your management company, or if you're working with an accountant, definitely do whatever is necessary to understand, and also to understand what your long-term needs are going to be as well, because yes, you're on this board for 1 year, 2 year, 2-year terms. I mean, maybe you have a 3-year term, but you're a fiduciary, you're a trustee for this corporation, and you think about it like you would think about any other corporation for which you're responsible. You want to anticipate what's coming down the pike so that you're not left empty-handed at a time of critical need. And one of the reasons I say for this, there's, that mantra in Florida, we don't buy green bananas, we don't, pay, we don't save for things that, may not happen during our term of governance. Well, I mean, that's really not the right attitude to have. You have to have the attitude that, hey, listen, we're going to have a fiscally sound operation where we have enough money to pay our budgeted actual expenditures. We have enough money in flexible funds so that if things come up, which they always do come up, that we have funds available for those. We have access to funds. If you don't have actual cash in the bank, you have access to funds to meet emergency expenditures, and you're otherwise are capable of attending to those needs, anticipating those needs and attending to those needs, both financial and otherwise. Email communications, this is a sore point with many people. Yes, you can use email to communicate, but you cannot use email to cast a vote on condo association matters. What does that mean? Does that mean that you basically have everything as a fait accompli and you get to the board meeting and it's almost like a consent agenda for a city or a county commission where they say items 7 through 17 are on the consent agenda, all in favor, pass and move forward? No. The whole purpose of having this sunshine requirements in Florida law is so that owners have the opportunity, should they so desire, to understand what's going on at their particular property. So if you're changing, you're changing vendors, you are making decisions to make significant repairs, you are hiring and firing employees, or otherwise making decisions that do require some thought and discussion. Even adopting rules, you adopt rules, you have a discussion. Why do we want this rule? How are we going to word this rule? What is the rule designed to actually accomplish? That discussion should be made at an open meeting where unit owners can participate and can otherwise become apprised of what's going on. Here's a question about electronic notice, just to go back to that. I have 40 out of 48 consents for electronic notice. Do I need 100% to proceed with electronic notice? Absolutely no. So we're not talking about electronic voting, we're talking about electronic notice, but I'll talk about both of it. For electronic notice, it's an opt-in process. So you could have 100 owners, 48 of them say, hey, don't need to mail me, just send me emails. I want all my communications via email. Well, then for your roster list, you can note, hey, these 48 people we can send email notices to, but the other 52 people on the roster list require mailed notices. It does reduce some of your expenses. It makes things a little bit easier for you. Most associations will send electronic notice as a courtesy to anyone for which they have email addresses, but that would not be considered the official notice unless you have that consent on file. So for the people that you have the consent on file, you don't have to send them a secondary mailing. For electronic voting, same thing. It's the board decision to implement an electronic voting platform, but it's the owner decision as to whether they want to use the electronic voting platform. So they want to opt in, they go online, they pick out their password or otherwise register, and then they get all their notices electronically, they vote electronically. But if somebody is not comfortable with that, then they say, no, don't, I'm not signing up for it. Just, continue to send me mailed notices. I don't know why this is working. So financial operations, and we talked about it a little bit. I'm actually going a little bit slow here. I'm sorry. So budgets, we talked about budgets. You have to include all anticipated expenditures. You want to include on your budget, there are specific requirements of the administrative code. You want to include the assessment per unit type, whether you do that on an annual basis or the monthly basis. Most people do it on the monthly basis, but technically you should have the annual assessment and then how it's payable. So it's payable on a monthly basis, payable on a quarterly basis. That will establish what the owners have to pay and how they pay. Same thing with reserves though. So on the condo side, we're going to talk about reserves when I talk about the new law a little bit. You have to have a reserve schedule. It doesn't matter right now, doesn't matter whether you haven't funded, have no money, have tons of money. You have to have that reserve schedule attached to your annual budget every single year. And when I say reserve schedule, right now, the law will require many associations with 3 stories or higher to obtain a professional reserve study, but I've been an advocate for professional reserve studies for as long as I have been in this industry, because it's really difficult for any member of the board of directors, I don't care how savvy they are or how familiar they are with facilities operations, to actually quantify all of the components for which the association is responsible, and then to estimate the remaining useful life and anticipated cost for repair or replacement of those components. The statute says, and still says, painting, paving, resurfacing, and that's what typically I'll see on the reserve schedules attached to the budgets that I review. But there are a whole lot of other improvements that will cost more than $10,000 to repair or replace at the end of the useful life. And that's in many associations, regardless of whether you're a townhome association or only a 2-floor, 2-story type community. You have, railings, you have, you may not have elevators, but you may have seawalls. You have all kinds of improvements. You have electrical systems. Some of the older condos right now are replacing all the circuit boards because they had those old circuit boards that are no longer in service and are dangerous. Go ahead, Jonathan.
Most importantly, your reserve schedule, if properly done by a professional, is one of the best ways you have of projecting your cash needs over the years. And it really helps you with doing your budget, because don't forget, if you're reserving for something, there's 2 different methods. There's the straight line method and the cash flow method. And the cash flow method takes into consideration all the different, preventative maintenance steps that you're doing for the association. But if you want to know where you're going to be in the association, I mean, a reserve study, depending on how old your community is, on whether and how, I hate to say it, but how wealthy your association is, could save a lot of agita with proper planning. Because, sometimes folks that have the wherewithal don't mind having, doing a special assessment once in a while and paying for everything all at once. But there are other communities that may not have that ability. And if you don't reserve for it, if you don't understand what year, you're going to have to paint, what year you're going to have to replace your roof, and it comes as a complete surprise, it's not good for anyone, especially your residents.
Well, you know what, and even in wealthy communities, nobody likes to be taken by surprise. So that reserve schedule is not only a great planning tool and puts the board members and the community manager on notice of what considerations need to be taken into account and what's coming down the pike, but it's the perfect disclosure notice.
Right. Exactly, 100%.
If I have a reserve study, if I was running a community association, I'd be sending it out every single year, and I would have it updated a minimum of every 5 years, because I want my owners to know what I know. And I know that the roof needs to be done in 2025, or the roof needs to be done and the elevators need to be done in 2027. And then in 2026, when we're talking about the assessment for the elevators, you have, instead of having everyone screaming at you, why do we have to do this now? Nobody knew about this. What's the problem? They're not even, they're working fine. I mean, maybe we get stuck every now and then. No, you say, listen, every single year in August or December or whenever you send it out, we've sent you a projection of the work that is that is necessary to maintain this property in a safe and reasonable condition. So, I find it disingenuous that you now think that with the fact that we need to replace the roof or, modernize the elevators is a complete and total surprise. It's a perfect disclosure tool. It's fabulous for disclosures to prospective purchasers. You want prospective purchasers to also understand what their financial obligations are going to be, not just what they have to pay on a monthly basis, but you want purchasers to know that, hey, if there's no money in the reserve fund and the roof is coming due in 2025, and right now it's 2022, well, that means there's only 3 years to save up enough money, or, in 3 years or 2.5 years, you're going to be assessed for it. And you want those purchasers to have the wherewithal to be able to pay those assessments or pay for the savings during the period of time when it's necessary. So we'll talk a lot about reserves, particularly for the 3-story and higher buildings and the new statutes. And I don't want people to really get overly nervous about the new statutes, because I believe, and this is just my personal belief, that there will be some adjustments to ease the burdens and of the requirements of the new statutes. But the purpose of the new statutes is to prevent a situation where portions of the property have been neglected, and it's past the point of no return. So there's so many communities out there, and I'm sorry if I'm on a soapbox a little bit, but so many communities out there, hey, we'll just patch it this year. We'll patch it this year. We'll patch it this year. Oh no, we can get a whole another 5 years out of it. We can get 5 years out of it. Well, lo and behold, if something bad happens, if a roof collapses on somebody's unit, or you have a monster water intrusion event that could have been avoided by replacing your roof or attending to waterproofing or what have you, then you're shooting yourself in the foot, because you've saved money by patching, and now you're looking at a situation where there are emergency expenditures that need to be made, plus all the inconvenience and hassle of dealing with some of the other damages that could be caused by that. In the HOAs, the laws didn't change for you this year when it comes to really budgets or reserve operations, but it's a bifurcated procedure. Reserves are, quote, considered mandatory if they're in the developer's budget when the property transitions from developer control, or if the reserves are voted in by the owners. Now, I've never had a situation where I've had members petition the board to add reserves to the budget, but just because the reserves are not mandated by law does not mean that the board financial and fiduciary obligations are any different. The board fiduciary still has to plan for the future. And if they believe in best interest of the association to include reserves in the budget, well, then you go ahead and include reserves in your budget as adopted by the board. So sections of the budget, I'm going to go a little bit quickly through here, because we did talk about it already, but the sections of the budget are determined by statute. Listen, everybody that's participating today, and even if you signed up and were not able to participate, you have the ability to download these slides. Not that they're all that substantive, but at least they have a little bit of tidbits for you. So don't be upset or take any umbrage if I don't go over every single thing on every single slide. One of the changes that happened in 2021 for condos, you have to adopt your budget 14 days prior to the start of the fiscal year. So a lot of times budgets aren't even adopted. They start in January 1, but you don't even have the actual meeting to adopt the budget until the end of January, the beginning of February. Be aware of that. Make sure that you now do your budget planning in September, October, so that you can get the budget out and adopted by mid to end of November. These are a bunch of changes to the collection of assessments for community associations. This was a very, very big change that arose from the 2021 legislation. One of the biggest changes is that before you can collect attorney's fees for collecting delinquent assessments, you have to send an initial notice. Most of you already do it. Most of you already by rote or through your management company, it's just automatic. 10 days after the payment is received by the association, or 15 days the delinquency date, a letter spits out from the program that you use to the unit owner saying, hey, we haven't received your February 1 payment. But now that assessment or that courtesy assessment notice or late notice has to have specific information. It must be sent to both the unit, the address of the unit or the home, and the address that you have on file for that owner if they're different. So if you have, if you have an address that you're sending notices to all the time, but the person doesn't live in the unit, send it to both. And that's the third item on here, notice of late assessment. And the timelines have been changed for the condo. So for HOAs, you suffered with a 45-day delay before that notice that comes from the attorney that says we're going to file a lien against you if you don't pay. Now condos are also in that same 45-day boat. So that notice of late assessment is a 30-day wait period. So think about it. You may want to change your collection procedures or your delinquency procedures, because now instead of sending that courtesy notice with only a 10 or 15-day window for people to pay, you now have to send a courtesy notice and give people 30 days to pay. After the 30 days, if there's no payment, you send it to your attorney or your collection agent for collection purposes. They send the notice of intent to lien. Well, then you have to wait 45 days before you can even lien the property. Once you lien the property, you have to send them notice of the intent to foreclose. You have to wait 45 days before you can actually file your foreclosure. So we're talking about 120 days before you're getting into court on a delinquency. And some of my clients traditionally in the past, like they wouldn't send, just one courtesy notice. They would send one the first month, one the second month, maybe even go into a third month before they even sent it over to the attorney's office for collection purposes. Well, now you're talking about 90 days on top of the 120 days, and that's a lot of period of time for bad things to happen. So you may want to be a little bit more diligent with initiating collections. I'm actually going to skip this for now because I'm going to talk about it with the new statutes to the extent that we have time. But I did already say condo, you have to have the reserve schedule attached to the budget. The way the board adopts the budget must include the fully funded reserves. You can only reduce or change the payment that would otherwise be required if you have a vote of the members, and the vote of the members must contain this big bold disclosure. For financial reporting, year-end financial reporting, the revenue categories are here. If you're over $500,000 worth of revenues, you can prepare. You're required to prepare audited financial statements, unless the members vote to waive or reduce the level of financial reporting required. Disclosures on the financial report. So there are different disclosures depending on whether it's an HOA or a condo. New laws in 2021 made your financial reporting requirement a little bit more important because the division, if you fail to provide notice of that the financial report is available or have the financial report done on a timely basis, the division can now say, okay, send me your financial report right now. And if we find that you're in violation, then we can say, division, that you're not permitted to waive or reduce the financial reporting for the following fiscal year, which is somewhat problematic because you don't have your financial report until 120 days after the fiscal year following the year for which the report is stated. At that point, you already have your budget in place. So if 4 months later or 5 months later, you're now in June or July, and now you get an order from the division saying, hey, you can't waive or reduce your financial reporting for the current fiscal year, Well, you know what that means? That means you might have to adjust your budget because you may have not budgeted for an audit. You may have only budgeted for the compilation or review that you've traditionally done. So it's important to remain in compliance. Rules and regulations. Whew. Lots of rules and regulations. The enforcement powers changed actually pretty significantly in 2021. I talked about these rulemaking powers. Well, and I talked about the test. There is that test. The test is for a board made rule. You have to have the authority. Whoever is making the rule, whether it's a board of directors or by vote of the members, there must be authority to create the rules. And authority doesn't come from the statutes, and it doesn't come from thin air. It comes from where? Your governing documents. So your governing documents have to give whatever body it is, whether it's the board or the membership, the authority to make rules regarding either use of the units, use of the common areas, use of the condominium property, which would be everything, and it could be limited. There are some associations that require membership votes to adopt certain types of rules. You have to have that authority. Secondly, the rule cannot conflict with any of the provisions in the documents of higher authority. So those rules and regulations, remember how I said that they fell right down to the bottom? If a rule conflicts with something that's in the declaration, whether it's an apparent conflict or an implied conflict, then the rule is not going to be enforceable because you're constrained, you're limited by what your declaration says. That is sometimes difficult to evaluate. And I often encourage my clients, hey, listen, if you're going to be adopting new rules, please just run them by me so that I can determine whether they're going to be considered valid and enforceable the way as written, or we can modify them to make them valid and enforceable. And then the rule has to be reasonable. What is reasonable? Okay, you tell me. The case law says it has to be rationally related to a legitimate association objective. So when you're adopting rules, you're not adopting rules just willy-nilly for the sole purpose of having rules. You're adopting rules to accomplish certain purposes. So you have to carefully tailor your rules to the purpose that you want to accomplish, which is whether it's something that you want to avoid, happening, or whether you want to encourage people to do something a certain way. You have to have that language written in a way that makes it reasonable for the owners to comply.
Lisa, for new board members, one of the things we've experienced is sometimes they get on a board and the board is pretty much changed out. And they'll notice that there's a lot of things that are taking place in the association that are actually described in the documents but are not being enforced. So rather than just start enforcing them, what we recommend is do something along the lines of a board resolution, where at a board meeting you say, whereas the documents say this, and we want to enforce it, so on and so forth, effective such and such a date, we're going to be enforcing it. Do it as a board resolution, the board signs it, send it to legal counsel to quickly review it, and then mail a copy to every single resident so that they know that starting on November 1st, you're going to be violating for hanging your clothes out in your yard, which was never violated before, or parking a derelict car in your driveway. But that way, at least there's some advance warning that you are now going to be enforcing something that is in the original documents, your original bylaws, rules, and regulations that was ignored prior, and it puts everyone on notice. And it's a way to make sure that it's not going to be challenged down the road.
Absolutely. And just as importantly, not only the notice purposes, it helps you overcome defenses that would otherwise be available. When we go into an enforcement on a rule type issue, you always hear, hey, selective enforcement, you didn't make so-and-so do it, and this one has it, and that one has it, you can't make me do it. Well, okay, by drawing that line in the sand and saying, okay, today's the drop dead date. After today, we're going to start enforcing this one rule. You're thwarting or overcoming that type of an objection or a defense. Same thing with waiver or estoppel. Hey, you told me last year I could do it. Well, yeah, last year I told you could do it. Maybe I should have, maybe I shouldn't have. But 6 months ago, we told you in writing, we're going to start enforcing it. So you can't rely on something that I said 6 months before an official pronouncement came out from the board of directors. And importantly, I'm sure you do this in your communities, try to tailor, as I said, tailor the enforcement to the rule. So not every single rule would require you to go to arbitration or pre-suit mediation. If you have built-in enforcement mechanisms that are more effective and more immediate, then you'll have a better success rate in enforcement purposes. But typically in condos and cooperatives, you had this mandatory but non-binding arbitration program. And there are all kinds of complaints about the arbitration program. It was intended to be really a user-friendly system so that people weren't necessarily required to have attorneys help them and make it a little bit easier and faster for dispute resolution, rule enforcement resolution. It didn't work out 100% that way. So the statute has now changed. For most rule violations, condos can take advantage of what HOAs do, and that's demand the respondent participate in what's called pre-suit mediation, a mediation session before you move forward with a lawsuit. So for the pre-suit mediation, it really makes everyone have skin in the game. Whether it's the unit owner that claims the association is in violation or vice versa. Because once you ask the other side to participate in mediation, each side has to pay 1/2 of the fee, and the failure to participate in the mediation process, whether you don't respond to the initial notice or you don't pay the fee or you don't show up, removes or eliminates your ability to obtain an award of prevailing party attorney's fees in a subsequent action. So let me give you an example, because I'm saying it in like the legal terms, but let's just say one of my clients, an association, has a complaint that an owner failed to maintain their roof. Okay, the roof is dirty. They've sent letter after letter after letter, and the homeowner failed to maintain the roof. Well, in the arbitration process, if it was a condo arbitration process, I would have to say, okay, we're filing a petition for non-binding arbitration to ask an arbitrator to require you, Mr. Unit Owner, to clean the roof. As it says in the declaration, that roofs must be maintained in a neat and clean condition without stains, mold, or mildew. So I have to file that. I have to wait for the arbitrator to respond. The owner has an opportunity to respond. We go through this entire process, and the roof is still in the same condition as it was. And I'm talking about a violation that may not be, as crucial as some other violations, but this is the process. You have to go through the process before anything happens. Pre-suit mediation, I demand pre-suit mediation. Hey, think of something. Oh, you have a not fair housing purposes, but you have an aggressive dog. You don't take care of your dog. The dog has been attacked other people, or is aggressive and growling and what have you. Well, if I say pre-suit mediation, you don't show up at the mediation or don't pay the mediator fee, I'm immediately entitled to file a lawsuit against you. So we don't have to go through the arbitration process. We don't have to wait for this entire arbitration process before we can actually file a court to obtain adjunctive relief. Most attorneys are now recommending that you utilize the pre-suit mediation process over the arbitration process because of the detractions that are listed here. It's non-binding and it's inconsistent, and there's really not a precedential value to the arbitration program. Official records. This is where many associations really have problems. And it's the division reports every single year since there was an ombudsman. This has been the primary issue that they have to deal with statewide. I mean, particularly in South Florida and now Southwest Florida, I think is like kind of catching up to us a little bit. But I'll tell you, access to records, record retention policies, and owner expression rights. It's so frustrating, even for me as an attorney, to deal with these issues, because you're on this board of directors, whether you're managing or you're doing it yourself or you're working with other types of professionals, you're responsible for the corporate operations, the corporate records, and owners under the statutes have a right to see those records. These are not your personal records. These are records that belong to the corporation. So it shouldn't upset you as a community leader if people want to see them, if they want to see contracts, if they want to see financial expenditures, they want to see checks, they want to see invoices, they want to see rules, they want to see portions of files where that reflect owner payment for assessments. They're entitled to see it. So really, please do not become upset or take umbrage when people want to review records. Now, I know, I deal with it quite frequently. There are owners out there that want to inspect records for sport or to annoy or to usurp all, management staff time, or to try to be annoying to you, or to, or because they want to try to ferret out something that they feel that you did wrong. None of that is a reason to withhold access to records. So the smartest thing that you could do, whether you're on Condo or the HOA side, and of course, Condo has the division that will help enforce, HOAs don't have that option, but the smartest thing you could do is set up a record retention policy and set up a procedure for access to records, owner inspections of records. When will they be held? Are there certain hours per week that you want to hold these records? Are there, where does the request to inspect records, where is it sent? Is it sent to management? Is it sent to the president? Is it sent to the management office? You want to have that all nailed down, because if you fail to provide access to records, or you fail to maintain the records that you're required to maintain, then there are penalties. There are penalties in the division side if you're on the Condo, and there are, the owners have the right to enforce this obligation through the court system, and they're entitled to obtain their attorney's fees should they prevail. So again, you want to make sure that you have a policy in place. And this is one of the reasons why the website, I think, is so effective, because to the extent that you could just upload records to websites, and you don't have to devote your manager's time, or you don't have to devote your staff time, or you don't have to devote your time as a board member to sit there and babysit somebody who wants to review 3 years, 5 years worth of minutes, 5 years worth of insurance policies, or what have you, then just make your life easier. Upload them to a site where they can have access to it. You can give them a password for it, and make everything a lot easier for you. But this is where a lot of associations really run into trouble, and it's really not something that should be as problematic as it is. There are some records that are not available to members: attorney-client privilege or work privilege documents, medical records of owners. Why would you have medical records of owners? Well, they could have somebody with special needs, so you have that information in your files so that you can handle those special needs if they arise. But right now, we're getting a lot of different medical records of owners or residents in connection with requests for reasonable accommodations. The information obtained in connection with the sale, lease, or other transfer, none of those background investigation reports are available to any of the owners for inspection. Personnel records of association or management employees are not available for inspection, and personal identifying information is not available for inspection. So you may have owner files. If you have owner files, and I do advocate for having owner files, so that things are, you can find architectural requests, or you can find particular issues in there, or next of kin, or people that are authorized to access the unit. Then what I always suggest is have a section in the owner file in a sealed envelope or some type of protected manner. You could still have all the records that you want to maintain in there, but at least they won't be easily available. So then if a unit owner says, hey, I want to see the unit file for 506, as the management or as the staff member, I can go to the 506 unit file, take out the envelope, the sealed envelope that has the records that are not available for inspection, and then feel confident that the rest of the file is available for that owner inspection.
And Lisa, with current technology, this can be handled through what is called permissions. So much of this, the folks can go into a decent site that has a portal. There's one usually for residents and one for boards. And much of what you're mentioning can be done right within the portal, and what is not accessible because of attorney-client privilege or personal information would be blocked out as not having permission for public use.
And let me tell you something, you know how much work is involved in that? Okay, I mean, you know how much work is involved in having to redact records for record inspection purposes? So I was involved in one case where they wanted, I mean, I'm telling you, it was thousands of pages of records, and all of it had personal identifying information because they wanted correspondence. And the correspondence, all, of course, had, it was email, primarily email correspondence. So they had the email addresses. So the email addresses, unless they're on file for consent purposes and on your roster list, they're personal identifying records. They're not records that are available for inspection. So we had to go through file after file after file and start redacting out email addresses and redacting out personal names or other personal information that was in all this correspondence. And it took forever. I apologize. There's a ton of questions that are being posted here that we're not going to have the time to get to most of them, but after the presentation is over, we'll distribute both of the questions to both Jonathan and I. We'll try to answer whatever we can, and we'll also send a link to the participants to those questions and answers. But emails, well, I just talked about emails. So the current ruling is still that board members to board member using personal email addresses and personal devices are not considered official records of the association that need to be made available for inspection. But how many emails do you guys are all, typing back and forth, and you're copying the CAM and you're including the CAM and you're including, other vendors, and it's really association business. Even if you are using your personal email address, it's still association business. It's still going to the CAM, it's still going to a staff member, still going to vendors. It really should be made available. I think we're going to see a lot more legislation or rulemaking through the government agency on this, because if you have to archive every single email that involves your community association manager, then that's going to be a monumentous task. It's going to be extraordinarily expensive to do, and it's going to just create a whole set of problems that we haven't encountered in the past. But right now, if you do have that, board member at happylandcondo.com type of email address, again, be cognizant that there should be a way of archiving that information because it is going to become relevant later. Okay, so I've talked about the websites, web portals required for condos with more than 150 units. And we talked about the documents that need to be posted to the website and why it's important to upload them on a timely basis, and how effective and how easy they can be for all types of purposes. So let me see what we got here. So I want to talk about I want to talk about insurance just very, very generally. So the types of coverage you have. Property coverage is your casualty type coverage. In a condo, it's regulated by statute. The property coverage is for damages to the property through as a result of occurrences or casualties. And that's the hurricane hits or any other type of casualty, including burst water pipes or baseball through the window of the unit type of a thing. General liability coverage, now more than ever, general liability coverage is important, and I've noticed that the general liability coverage is becoming far more expensive than it was in the past, and the associations are requesting a lot more coverage than they did in the past. So typically you would have a general liability policy of like 2 million, maybe with a 5 million umbrella. Now I'm seeing the general liability policy 5 million. I know associations are asking for $10 million umbrellas, $20 million umbrella, $20 million umbrellas, and the insurance companies are becoming somewhat loath to offer that coverage, or or they're going to charge you for it. Same thing with directors and officers. Typically, I always saw 1 million of coverage with the $5 million umbrella, or maybe $2 million coverage. Right now, I know that there's a trend in the industry for people to ask for more coverage under their D&O policy. You're required, condos are required, associations are required by law to have a fidelity or dishonesty policy. That is for employee or board member theft or defalcation. And I also think it's important to have some kind of cyber policies either embedded into your other policies or as a standalone policy. The directors and officers sometimes include some cyber loss claims. The general liability can sometimes include some cyber loss claims, but again, so much now is computerized. I mean, all your payments are computerized, all your owner information is computerized, and it's so easy, no matter how much safeguards you have in place, it's so easy for people that really want to obtain that information to obtain that information. So these are some typical claims that I outlined, for example purposes. Estoppel certificates. Estoppel certificates are basically, was always conditionally considered a statement on account. You need an estoppel to close or to buy because you want to know what's owed to the association. And the lender, more importantly, wants to know what's owed to the association so that the new owner takes over with a clean slate. So the estoppel fees and estoppel requirements are regulated by statute. In the condo side, the association must designate a website or a person for receipt of the estoppel certificates. They must be signed by an officer and authorized agent of the association, and they must be furnished to the person requesting their certificate within 10 business days. The fees that I have on here, acceptable fees for estoppel certificates, were just updated in, I believe, July of this year. So it's a little bit more than what I have here. I think the fee was is raised to $299, and the other add-on fees were also, also were increased somewhat. I can ask Jeff, who's facilitating this presentation, to include the new fees in the mail out that happens immediately after here. So what I'd like to do now is also talk about here. I would like to now talk about what happened in 2022 when it came to the law during the special session. This is going to be available when you check out and you fill out your evaluation forms. So don't be concerned when you're, that you're not absorbing everything that's here. You'll be able to print this for your own purposes and reference later. But the new laws that were adopted at the special session this year will require both milestone inspections and mandatory structural integrity reserve studies. So these are for properties or for condo associations and cooperative associations of 3 stories or higher. And the milestone inspection is somewhat similar if you're in Miami-Dade or Broward County to the 40-year inspection. But the milestone inspections are going to be required as of the 30-year deadline rather than a 40-year deadline. If you're not on a coastal condominium, if you're within 3 miles of the coast, they're going to be required at 25 years. And then both of them are required updates every 10 years thereafter. And the milestone inspections, you must have an engineer come out to review the primary structural systems at the building and determine whether there's any substantial deterioration. They prepare a report. the report is furnished not only to your unit owners, but it's furnished to the local building official, and you have a certain period of time to actually attend to the repairs noted in the inspection report itself. So a phase one report, a phase one inspection would be the general visual inspection. And if the engineer or architect does not find substantial structural deterioration, then you don't have to move on to the phase two of the inspection. But under most circumstances, you're going to find some evidence of structural deterioration. It just happens in 25-year-old or 30-year-old buildings. And you're going to have to address those requirements. So once you receive the report, you must, as a board of directors, must distribute a copy of the summary prepared by the inspector to all of the unit owners. And you're allowed to do it by electronic mail if you so desire, and the owners have consented to receive notice electronically. If you fail to obtain the inspection, then that is going to be considered a breach of your fiduciary duty. And also the managers are obligated to obtain the inspections. So there could be penalties against the manager. I'm hoping that will change somewhat, but there could be penalties against the manager if the community fails to obtain its required inspections, even if the manager did whatever they possibly could to force the board of directors to engage the persons necessary to perform this inspection. So again, the immediate deadline does not come into play. When does it come into play? So by 12/31/24 is when the initial inspections are going to be due. But that doesn't mean that you should hold off on it now. So if you're not in Miami-Dade or Broward and your building is 25, 30 years old, or closely approaching either one of those, my recommendation is to act now. I mean, engineers are in very, very high demand, very, very high demand. And we have not as many engineers as may be necessary to attend to all of the backlog of the buildings in the entire state of Florida. So doing whatever you can early is going to be most beneficial for you and your community association members. Why is it beneficial? Well, number one, if you do have deficiencies and you're doing the inspection before the 25 or the 30-year mark, then you have time to get that stuff worked out, fixed, before you have to submit the actual report to the building official. So whatever you can get resolved before you're actually required to submit the report to the building official is great, because then you'll be done with the process before you even begin the process.
And
Secondly,
more importantly, funding.
Well, that's exactly what I was going to say. Secondly, if there is significant work that needs to be done, don't you want to have time to save up for the money that you'll need in order to attend to those repairs? Instead of doing one special assessment all at once for all of this work, maybe you can divide the work into 3 years worth of different projects, and that will ease the burden on some of your owners. So again, the structural inspections, milestone inspections are going to be required, as of today, as are for buildings 3 stories or higher, structural integrity reserve study. Structural integrity reserve study. So we talked about reserves earlier. Jonathan and I are both big advocates of reserves. We work with reserve professionals for years, but this notion of a structural integrity reserve study never existed before this law was passed. So hopefully there'll be some adjustments to make the reserve study that's required by the statutes marry or conform to the reserve studies that have been traditionally prepared, over the years throughout the country, even if there are some additional requirements for Florida properties, condominiums and condominiums and cooperative associations. So the structural integrity reserve study, in my mind, seems to somewhat overlap, or is, kind of conflates the two processes, whether it's a reserve study or a structural inspection. structural inspection, we all know, is for the purposes of evaluating existing conditions and advising whether there's any remedial repairs that are necessary to make the building or the component that's being inspected function as it was originally designed, or to be as safe or as good as what it's supposed to be. A reserve study is traditionally for completely different purpose. So the reserve study is traditionally to say, hey, here's what we're responsible for. Here's when those components are going to outlive their useful life. So we need to be prepared in advance to address those components. But all reserve studies are predicated upon performing regular maintenance, because you could only realize the expected useful life of a component as advertised if you perform the maintenance that is required to keep that component in good condition. So these reserve studies are going to evaluate all of the items that are listed on this page right here, A through J. We call them the G factors because it's in section G of the statute. And after a certain point, after 12/31/24, associations are not going to have the ability to waive funding for these components, the items that are included in the structural integrity reserve study. And in my opinion, the way the law is written right now, that applies not only to buildings 3 stories or higher, it applies to all condominiums because of the way that the law is written. That may change as well. But again, after 12/31/24, you won't be able to waive that funding. So you want to have, as I said before, act as soon as possible so that you can prepare for whatever your financial obligation is going to be at the time that the law does become effective. Even if there's some alleviation of some of the requirements, whatever you can do now to put yourself in a position to be able to comply at that time is going to put your association, your community way ahead of others. So you'll have less drawbacks, you'll have less financial constraints, and it'll be, in my opinion, valuable for marketing purposes, as well as the peace of mind of all of your residents. So I think I say in here, if you fail to complete the structural reserve study, if you're required to do so, that also constitutes a breach of the fiduciary duty and can subject individual board members to exposure to personal liability. We don't want to see that happen, obviously. Good things are happened as a result of this bill. I mean, now the developer-controlled associations are required also to have a structural integrity reserve study performed, and also required to fund those reserves during the period of developer control. That's fabulous. You know why? At the time a community is first being constructed is when the reserve obligations are at its lowest. I mean, every component in a brand new building has I would say, a minimum of a 10-year life, and some of them could have 30 years or even more of a life associated with them. So at this point, at the beginning, at the inception of the condominium or cooperative property, cooperatives aren't really being developed now, then that's the lowest funding obligation you'll ever have until you actually replace the particular component for which you're funding. Your official records are required to include the structural integrity reserve studies, the financial reports, and the inspection reports. All of that documentation is going to be available for potential purchasers, and that information has to be also reported to the on the association website if you're required to have a website. There's also a reporting requirement. The reporting requirement is really, really simple and easy. I think I have it right down here. All you have to provide is this information: number of buildings on the condo property, that are 3 stories in height or higher, the number of units in those buildings, the addresses of the buildings, and the counties in which the buildings are located. The division just published a format for which you can even go online and provide them that information, but they're being very, very generous. They say, no matter how you get it to us, whether you get it by snail mail, drop it off at our offices, or email to us, we'll take the information and, you know, we're going to compile it as is going to be required by the state.
Hey, Lisa, we even, just as an FYI, this is relatively new. We have that on our website as well. Under the links area, we have a link to do it online directly for the state, as well as a form we created for anybody's use to make it easier for them to either mail it in or fax it or email it.
That's wonderful. Wonderful. So right, go to our website. We have the form right there. You can just fill it out. It's very, very easy. So I did kind of fly by the second part of our presentation. I apologize if I went too quickly, but that means we have some time to answer some of the questions. And some of these questions are, you know, really, really great.
But if I may, just before you get into the questions, I'll be quick, I promise. Right now, folks, find the chat button at the bottom of your interface and click it so the chat window opens up. I'm going to place the link for the evaluation in there right now. And then when Lisa is done with the Q&A, I'll go over again how to save the certificates, which forms with your confirmation submission screens. For those of you who need that, I know not all of you need the certificate, but if you do, I'll go over again how to save that, print it, so on and so forth. But the link is in the chat right now. Back to you.
Okay, thank you so much. Well, I'm going to start from the at the end of the questions as opposed to going from the beginning. But there's a question here. Assuming the association has a large construction loan and it is sued, is the association obligated to inform the lender? So are you talking about in connection with a purchase of a condominium? It's hard for me to really understand what that is, but your construction loans, if you do have a large loan, it will be reported on your financial statements, and it will also be reported on your year-end financial statement. So that information is important. If there's a special assessment that was levied in connection with the loan, that information will also be on your estoppel certificate. So for the sale, typically, well, I shouldn't say typically, because right now there are various ways of handling this. Some associations have a due on sale clause, meaning that the remainder of your special assessment will be payable in connection with the actual sale transaction. So the new owner will not be obligated to continue to make special assessment payments under that fund the loan. Alternatively, and this is what I've seen more frequently, is that if it's a long-term construction loan with a long-term special assessment, 5 years, 10-year special assessment, the purchaser, that information will still be disclosed on the estoppel statement, but the purchaser will take over the remaining payments over the life of the special assessment. Homeowners association do about outdated rules and deed restrictions. This is a very, very common question. And if your rules, your community documents are really intended for your benefit. Now, when the property is first developed, they're intended for the developer's benefit. The developer wants to sell units or houses, so they create the deed restrictions in the way that they feel is going to be the easiest to sell and the least restrictive. But for your communities, you're a living, breathing, forward advancing community, you want to make those community documents work for you. To the extent that you are able to obtain the membership vote to make those revisions, amendments are strongly encouraged, not only to comply with the current statutory requirements and to overcome some of the issues that have been raised in lawsuits or that have otherwise been problematic, but in order to improve your ability to enforce the documents, to tailor the restrictions to your current needs, to more clearly define maintenance responsibilities, insurance responsibilities, liabilities, and to update your ability to collect those assessments. One of the good things that also happened as a result of the 2021 legislation is that if you have covenants or rules or requirements in your deed restrictions, in your recorded deed restrictions that are considered discriminatory, whether they were intended to be discriminatory or just have a discriminatory intent. Now you don't need to go back to your members to vote to amend, to eliminate those amendments or those restrictions, regardless of whether you've enforced them in the past. So many of the communities were developed, HOA communities were developed, and it said no children under 12. Very, very common. Well, you can't enforce an age restriction unless you're considered a housing for older persons community, a 55 and over community. So unless you meet all the qualifications for being 55 and over, that restriction that says no one under 12 is allowed to live here is illegal and unenforceable. And you just might have ignored it. What was happening is that you had people testing those particular communities and filing discrimination lawsuits against those communities, even if they weren't enforcing the restriction itself. Right now, instead of just non-enforcing it or ignoring it, you can go ahead and record a resolution saying this is eliminated from our document. And there may be items in your documents that have a discriminatory effect, even if they're not intended to be discriminatory, that you want to get rid of. So that's what you do with old or outdated deed restrictions. Rules and regulations, if the board of directors has the ability to amend the rules and regulations, again, you're still constrained by the deed restriction. So you may need to change your deed restriction before you can change your rule. Okay. Okay, when there's a lawsuit filed, okay, this is actually a follow-up to the question that I was answering before. If there's a lawsuit filed against a condo association, should this be listed in the estoppel certificate? Any lawsuit in which the association faces liability in excess of $100,000 is required to be disclosed in your frequently asked questions and answer sheet, and also is disclosed in the estoppel certificate. The lenders will routinely ask whether the association is subject to litigation, if the litigation is being covered by insurance, or is not anticipated to dramatically impact the financial stability of the community, then the transaction will most often close. But there's been some modifications to the Fannie Mae and the Freddie Mac estoppel forms or mortgagee questionnaires that make the disclosures far more specific and intrusive than they were in the past. So we're going to see in the next few years, and I know you've dealt with this Jonathan, where now the burden on providing all the information to assist in a transaction is becoming far more cumbersome. It's becoming more expensive, and there are associations that are just not inclined to do so. And the mortgagee questionnaires you're not required to actually complete those documents. Now, of course, if you don't comply with the mortgagee, you won't get the loan and you won't be able to sell. Go ahead, Jonathan.
Right. That is being changed somewhat. In fact, all day today, there is a Zoom where the Florida CEO MC, the CEOs of management companies have been interviewing various state Senate legislators to find out, what their stances are on various things. And one of the things that the Florida CEO MC is working on is insurance and is some of these new legislations, because we as a management company we're not licensed engineers. We're not licensed anything. We're not allowed to go in there and answer questions that would require a license that is outside of our purview. So it's made it really difficult. So usually the condo questionnaires and the questionnaires that are being utilized are not something that we want to participate in. If we can, we'll answer it, as long as we don't take that onus of responsibility.
And I agree with you. It's not your obligation, and nor should you be exposed to liability for making statements that you're not capable of making. I mean, some of the questions ask you whether there are any significant structural deficiencies. Well, unless you've had inspections performed, you wouldn't even may not even be aware of that. And I would be loath to say that my building suffers from significant structural deficiencies. I would say, listen, we had an inspection report. Here's a copy of the inspection report. And the inspector made recommendations or certain conclusions, and you can read them for yourself. But to have a management company go out on a limb, or a board member go out on a limb and try to say, are there any special assessments anticipated? Well, you don't know. I mean, yes, you have projects that are coming up in the future, but you don't know if you're going to fund them through special assessment or some other means, and you don't know when those projects are definitely going to.
Yeah, exactly. And there are some even more specific questions. And for those associations that are self-managed, board members have to be very careful. And I would suggest looking to legal counsel before they answer any of those questions, because it could bring liability onto them. So,
And what I've done is it has to go client by client, because, it's pretty kind of specific client by client. But what I've done is try to assist the association with sample answers that I know that are specific to that particular community, so that they are prepared to go ahead and answer. Or give them advice on how to answer the questions, to try to facilitate the process, because you don't want to lock the process up by being recalcitrant, but you also don't, want to take on obligations that go beyond your responsibility. Why take on obligations that go on beyond your responsibility? So estoppels are required to contain certain information like parking spots. Be careful about what you put into those estoppels, because people are going to come back and say something about it. Estoppels are required to disclose whether there are any known violations associated with the unit. Well, be careful about that, because if you fail to disclose it in connection with the sale, you may be precluded from trying to enforce it later. And with the mortgagee questionnaires, anything to which you cannot answer that the answer to, there's no guessing involved. If you don't know the answer, you can't answer it, or you have to answer in a way that is appropriate for the knowledge that you have at that time. So I see we're right at our 2 o'clock mark. Jeff, what do we have as far as timing, or should we?
If you want to do a couple of, first, I want to say that anybody who needs to go, the Q&A part is not part of your requirement. You can hang out with us a little bit longer if Lisa, if you want to answer another question or two. But before we sign off, just so everybody is aware, I will go over once again with a screen share to show you how to do the evaluation and how to save your certificate if you haven't already figured that out. So if you want to do another question or two, I'm good on time. It's entirely up to the two of you.
Okay, so so there's a couple of questions I do want to ask. The slide about using email to vote apply to HOAs. Yes, directors of HOA communities can likewise communicate via email. They cannot vote by email. So there's no such thing as like voting by email. Electronic voting is a process that we talked about. Electronic voting is different than email voting. Email discussions are perfectly appropriate. It's just a matter of how you couch those email conversations and who you include in those email conversations if you want those email conversations to remain private. Here's a question that you might be able to answer, Jonathan. Is a component method better or worse for pooled reserves? Let me just say first, under the way the new statute, the active statute, the 2022 statute is for condo and cooperative associations, then there's some difference of opinion in the industry. Most people believe that you're not going to be able to use pooled method component funding for the items that are listed as specifically in the structural integrity reserve study. Hopefully we'll see that modified too. Why is that? Because the new law says that you cannot vote to utilize one reserve fund for another reserve item. And when you have a pooled reserve, the pool is available for all reserved items. But Conversely, there are people to say that, hey, listen, if you have a pool and the pool includes 5 things, if you spend the money on any of those 5 things, you're spending it for the purposes for which the money was collected. So that will hopefully be clarified, but tell us your experience.
Yeah, we've found, you know, the whole pool reserve thing started and started in about 2002, 2003. And we had great discussion about it back then, but it really makes sense to do, you know, they've identified asphalt painting and roofing as the 3 main components that should be reserved separately for. And I believe that's important because those are the 2 highest items. But when you pool your reserves, it makes more sense to do that because despite how accurate a reserve study may be, you know, equipment and structure has a way of disappointing you when you least expect it. So you need to have that, flexibility to use the funds where you need to use it. Also, it could change based on the preventative maintenance that is done on that particular item. So it may not need to be, you know, you may have one item, your pool equipment, you know, your titanium heat exchangers for the pool may not need to be replaced as quickly as it says in the reserve study, but you've got, you know, your generator that's giving out and you're going to have to replace that. So I think that the pool method is a better way to go because you can group a lot of small items without having to go through legal hoops every time you spend a component money in one area when it should have been spent for another area. So with the pool method, you have a little more flexibility. And as long as you have a prudent and fiducially responsible board, and as long as those funds are used specifically for that group of reserve items, I think, in my personal opinion, that is a much better way to go.
So I want to thank everybody for participating today, and I want to thank RealManage for setting up this board certification presentation. There are a number of questions that I did not have time to get to, and we will distribute them. I'll distribute them to both to Jonathan and myself. We'll try to answer as many as that we can and distribute that information to you in connection with the follow-up to today's presentation. But please download the materials, and including the Word document that I reviewed or showed you in connection with the new laws for the 2022 laws. And thank you again, Jonathan, for allowing me to participate with you and for your valuable input.
Thank you so much, Lisa. You did most of the work, all the work, in fact. But I did try to answer several questions that I thought did not fall under legal practice, you know. So hopefully we've gotten to some of them at least.
And stay tuned for Jeff to explain the certificate process again. Thank you again.
And thank you, Jeff, for putting this all together.
Oh, yes.
Well, thank you both. Great job as always. Pleasure to work with you both.